reaction to the latest on Zuma's corruption trial. We're joined by Accountability Now's advocate Paul Hoffman. Thank you for your time, Advocate Hoffman. A victory for Zuma here as he gets his postponement. It was for a pre-trial hearing, though. What kind of precedents will this set, considering we are now in a virtual world?
Morning, Annika, and good morning to your viewers. Thank you for the opportunity. I think the judge has adopted a particularly cautious approach to the application for a postponement. Every accused person, including Mr. Zuma, is entitled to a speedy trial, but in this matter, the delays are almost legendary. I was still a young man when the case started, and you can see on your screen that I'm not anymore. So I think that the two things that could change between now and the 10th of August, which is the date to which the hearing of the special plea has been postponed, are that Mr. Zuma, I see your husband on the screen there, sorry about that. Mr. Zuma is either going to still be in prison, or the Constitutional Court is going to decide to terminate his imprisonment, whether temporarily or permanently. That is still in the lap of the Constitutional Court. And the other thing that could change between now and then is that the third wave of the COVID pandemic may have broken by then. As we all know, every time Mr. Zuma appears in court or has a tea party at Nkandla, a super spreader event occurs. So I think that the judge has decided to adopt a cautious approach. He's kept the back door open, and he's going to have to decide at the beginning of the hearing on the 10th whether to postpone further, and if not, whether it is going to be necessary to hear oral evidence in the context of the special plea. The state's attitude is that there are no material disputes of fact, and you don't have evidence if there are no material disputes of fact. So that is where the matter stands at the moment. On the 4th of August, the parties are given the opportunity of providing laundry lists to the judge in relation to why they say the matter should be further postponed, or why a virtual hearing is still not appropriate, and he will put that into the mix when the court reconvenes virtually on the 10th of August.
Advocate Hoffman, what does this mean for criminal trials in general? We do know that there's another special plea application for the recusal of Billy Downer that's going to be heard next. But in terms of an actual trial where, for instance, an accused may want to cross-examine somebody, surely a virtual hearing will have its challenges.
Yes, I don't think that a virtual hearing lends itself to the process of cross-examination of a witness giving oral evidence, and the general trend is that you deal with preliminary matters, with matters that can be dealt with on paper rather than through oral evidence in relation to criminal trials. In civil trials, they have allowed matters to proceed, and they've allowed cross-examination to be conducted virtually, but it's not as satisfactory as everybody being in the same place at the same time, and the cross-examiner able to see the whites of the eyes of the person under cross-examination, and technology not getting in the way of the search for truth that takes place in every criminal trial.
Advocate Hoffman, an attorney we spoke to earlier, said that the court had taken a very safe and cautious approach, but that's pretty much been the case with the Constitutional Court too, giving Jacob Zuma several chances to present himself and to take part in the hearing before his contempt ruling.
Yes, I think that we need to bear in mind that justice needs to be done, but also needs to be seen to be done. Though I would agree with the attorney you interviewed earlier that a cautious approach has been adopted by the judge in this matter. He could have today said, I want to hear argument on why there is the necessity for oral evidence in relation to the special plea. You would have heard Advocate Trengrove for the state yesterday suggesting that what Mr. Zuma wants to do is interrogate the prosecutor and other members of the National Prosecuting Authority in circumstances in which it is not material and not appropriate. So the state's attitude is this whole special plea is excipiable, which means it doesn't make out a case in law, and that there is no need for any oral evidence on it. Mr. Zuma's team, on the other hand, is taking the attitude that there are areas of disputed fact that relate to the special plea and that they would want to test those disputes of fact by leading evidence on them, although that's not really suggested on the papers, and by subjecting those who give evidence on them on behalf of the state to cross-examination. Now, that ruling is going to precede the actual determination of the special plea.
All right, thank you so much. That was Accountability Now's advocate Paul Hoffman reacting to the latest Zuma judgment. The case has been postponed to the 10th of August. Well, for more